Senator Duplessis calls Senate Bill 218 by Senator Duplessis is enactment of the Code of Criminal Procedure relative to post-conviction relief to provide relative to applications for post-conviction relief based upon a conviction obtained by a non-unanimous jury.
Senator Duplessis, on your bill.
Thank you, Mr. President. Members, you all are very familiar with Senate Bill 218 right now, even if you don't know every moving part of the bill. I'm sure you have spoken with someone or someone has spoken with you about this bill. I brought it up about a week or two ago, and you all allowed me to amend it. And what I'd like to do, if you don't mind, just to put the bill in its proper posture so I can explain it in a way that I would like for it to ultimately be voted on, is to offer up one more set of amendments.
Okay.
Oh, they have. Yes. And Alan is working right now with staff to get them so you all can read them. But I have worked tirelessly and extensively with the District Attorneys Association in trying to address their concerns with the bill. But what I have right now is another set of amendments. You all can't see them yet, but if they are and when they are presented, essentially what these new amendments would do would allow for anyone who is charged with a sex crime that the victim would not have to testify again, that they could introduce prior sworn testimony to not subject the victim to that experience again. There's also language in the new set of amendments that would try to tier the bill. It would tier it so that cases tried in before a certain period of time, 1999, those are cases that were finalized before 1999 will be prioritized within the first year. Cases between 2000 and 2010, the second year, and cases between 2011 up until the law was changed in 2019, that would be the third tier as a way to try to give the district attorney some relief, because they've argued that this would be an overload for their dockets or for their staffs. So while that amendment is coming, I guess I'll just go ahead and get started on the bill and just describing what SB 218 does. What SB 218 does is that it provides a legal path for people who can prove their conviction was not unanimous to finally receive a new constitutional trial. The bill offers a path with multiple guardrails to make sure that the process is efficient and just. I want to be clear, the bill does not open the floodgates of prisons. Nobody will be freed because of this bill, without going through a constitutional process in which the DAs can choose to try to retry or offer plea deals to people. Despite a lot of misinformation that's been put out there, this is not going to let anyone automatically out of prison. They would have to first prove by clear and convincing evidence that they first had a non-unanimous jury, and not a non-unanimous jury where just 10 people voted to convict, but a non-unanimous jury where 10 people voted to convict and the other 2 voted to not convict. That is a very, very important distinction. For decades, Louisiana district attorneys were able to get convictions even though 1 or 2 jurors were not convinced beyond a reasonable doubt that the state had proven its case. This bill restores faith in the criminal legal system and does so in a way that is safe and efficient. I have already discussed some of the amendments that I think provide additional safeguards. Currently, there is a 1-year statutory requirement for district attorneys to make a decision to retry or to enter into a plea deal. This gives the DAs 3 years.
Senator Duplessis, I do have the amendments now.
Okay, I'd like to offer up those amendments.
Senator Duplessis offers up set number 1670.
and I've mostly described them already.
Amendments? Oh, okay. All right, members, take a second, look at those, and then we'll have the author just describe.
See, I have a question on the amendment.
Senator Morris, you ready to ask your question now on the amendment? You want to wait? Senator Morris on the amendments.
So the amendment allows the introduction of prior sworn testimony in another criminal trial
Yes.
in the future.
Yes.
So first of all, I understand the first hurdle is the clear and convincing evidence, right, to get to that point. But on a subsequent retrial, you still have to prove the case beyond a reasonable doubt, which is the highest level.
Yes.
And you think a DA can prove that up by introducing a piece of paper and telling the jury to read a 500-page record?
I do. Every case is different. I'm not suggesting they can do it in all cases, but they would have to take a hard look, make the determination, and decide whether or not they think that they can or not. And if they can't, they probably won't retry that case. If they
So a lot of these cases you suspect will get dismissed because
no.
they won't have- You don't think?
To say, see that, and that's where we start to muddy the waters. To simply say, to make a broad statement that a lot of these cases are going to get dismissed, we don't know because they haven't been reviewed in such a way
But there's
to know.
a chance.
Well, they wouldn't be dismissed. There would either be a retrial or there would be a plea. So nobody's just walking scot-free unless they're found not guilty.
Right. Well, if the DA decides not to charge him and retry the case, that happens all the time with hung juries.
They retry them all the time, and they get convictions all the time. The Supreme Court case, the Ramos case, that he was retried and acquitted, but there are a lot of cases, Orleans Parish in particular, where our DA is retrying several cases, some old, some not so old, and getting convictions.
Mm-hmm. So, but do you think it's likely to get a conviction even if somebody's guilty by giving the jurors, literally a trial court record could be 500,000 pages and have them read that during the course of a trial and try to convict them with that?
I think that's too speculative. I think that the DAs.
Well, that's not speculative. If it's in your bill.
No, when you say what's likely or not likely, I can't say what's likely or not likely because every case is different.
But under your bill, the DA would have the opportunity.
They would have an option
to do that. And if they did, you'll concede that a trial court record's probably going to be 500 to 1,000 pages, probably more.
I can't say how long a trial record is. Some trial records might be shorter. Some trials happen in a day. A lot of people get convicted in one day.
Right, but
and a trial record may not be that long.
A half-day deposition can be a.
But that's a deposition. We're talking about a criminal jury trial.
It's the same thing. You answer questions and ask them. The court reporter takes it down.
Right.
And a half-day deposition can be 400 pages.
Right. I don't think every trial is the same. And this is just trying to provide the opportunity, number one, to determine whether or not there was a non-unanimous jury conviction. From there, the district attorney can then make the assessment based on their discretion, whether or not they want to undergo or take on a new trial or make a plea offer, which most of these people were offered at the outset before they went to trial, however long ago it was. Mm-hmm. So the challenge that we're faced with right now, and this is one of the things that I've talked to Zach Daniels with the DA's Association about, is that right now there's a clear difference of opinion on how many cases that there actually are, right? So
there's no way to know that, right? Because every DA is going to make their own independent judgment on whether they can secure a conviction. I mean,
well, we have some data. When I say data, there are groups that have looked at this and have made determinations on how many cases there are in each respective judicial district. Some have more cases than others. There are some parishes throughout the state that don't have any cases. So this really wouldn't even affect some DAs, quite honestly. And in those cases, in those instances where there are cases, if you spread this out over 3 years, it may be the addition of 1 or 2 district attorneys, maybe that it would require to do additional work and make the assessment. But right now, there's no firm agreement on exactly how many cases that there are out there.
Are you aware of any particular defendants who were convicted under a 10-2 jury verdict who have demonstrated to you that they were actually innocent? Or
Demonstrated to me?
yeah, well, as an author, I mean, like, do you have examples like, we needed to pass this because
Yeah.
John Doe was wrongfully convicted, it was 10-2, and he was innocent?
Yeah,
And
in committee. I'm glad you asked that question. And I hope the members hear this. For those of you all who didn't sit in Jude B, I hope that the members hear this, because this is really important. Senator Morris asked about actual examples. So Jermaine Hudson served 22 years in prison, not for a crime he didn't commit, but for a crime that never happened. He served 22 years in prison for a crime that never happened. He was convicted by a 10-2 jury. He sat next to Mr. Bobby Gumpright, I believe I'm saying his name. I hope I'm not messing up his name, but
regardless, did he receive post-conviction relief?
I don't believe
before his sentence was?
I don't believe he was freed on actual innocence. Another case is.
But he did receive post-conviction relief.
I'm honestly not clear on the exact way he was released.
I've met him, and he's a nice gentleman, and I don't know all the details of his case, and that's wrongful. But he was released without serving the full sentence.
Well,
under existing law,
but
right?
you asked me if I knew anyone who had been convicted by a 10-2 jury
and you told me,
who didn't do the crime.
Right.
And that was the question.
And you answered it, and I'll ask a follow-up question.
So another gentleman served, I believe, 37 years, Herman Evans. I know for a fact, he was not released on actual innocence. He actually ended up pleading just to get out. He was convicted by a 10-2 jury. He's been at the Capitol. He's actually at the Capitol right now. He served 37 years. That's him sitting right there. He served 37 years for a crime he didn't commit. He was convicted by a 10-2 jury. And to get out, he had to plead, because the barrier and what it takes to be released on actual innocence, the standard is so high, very few people actually
new evidence.
It's tough. And it's tough to be able to prove that new evidence. So just to get out, he pled, and he was convicted by a non-unanimous jury. So actual innocence, it's there, but it's really, really hard to achieve.
I understand.
Yes, sir.
Thank you for answering.
Yes, sir. Thank you.
Okay, Senator Jenkins for a question on the amendment.
All right. Thank you, Mr. President. Senator, our U.S. Supreme Court has already said that these jury verdicts need to be unanimous, right?
Right.
And what happened, it just did not make it, the ruling, they did not make it retroactive.
That's correct.
And so basically, we have some people caught in the system that really need some kind of post-conviction relief, and that's what we're dealing with at this stage. Would that be correct?
That's correct.
And in most of your post-conviction cases, a jury trial is taking place, you're going to be dealing with transcripts or some kind of written documentation. I mean, regardless, that's going to be something we probably would have to deal with. And I believe that's a part of what the amendment is trying to achieve here. Is that right?
That is absolutely right.
And further in your amendment, it appears what you're trying to do is set up a system, since there seems to be some concern about managing the caseload, you're trying to set up a system that would make it more manageable for those persons who, including the district attorney's office, who would have to go back maybe and look at some of these cases.
Yes.
So essentially, that's what we're trying to do in the amendment.
That's what we're trying to do.
Okay.
Yeah, it's not an ideal scenario that we're in based on the rulings of the Supreme Court, but we're trying to do as good of a job as we can. There is no perfect way to solve this problem, but we believe this is the best way.
Right. Well, I certainly feel like what you're trying to do in the amendment to try to work it out, so it'll be a more manageable situation. The interests of justice deserve that.
Thank you. Thank you, Senator.
Okay, I see no more questions on the amendment. Are there any objections to the adoption of the amendment? Seeing no objection, amendment is adopted. Back on the bill, next set of amendments.
Amendments sent up by Senator McMath. They are set number 1873. 1873.
On your amendments.
Thank you, Mr. President. Members, we heard testimony in Jude B, which I thought was compelling enough to continue the conversation and try to come to some sort of compromise and resolution. These amendments, which I were going to offer, was going to establish a special committee on parole for non-unanimous jury convictions for the purposes of reviewing these cases. This is something that I'd worked with the DA's Association on. They were in a position to offer this compromise and be in support of it. However, the other side just couldn't get there, and so I'm actually going to withdraw these amendments.
Okay, Senator, withdraw the amendments. Next set of amendments. No further amendments. Back on the bill, Senator Seabaugh for a question on the bill. Normally you ask those questions so we all can hear it. Just.
I was hoping I could finish the presentation. All right, come on. I can wait. Come on. Yeah.
He said he
All right.
wouldn't
Yeah.
finish this
Well,
presentation.
I was still explaining the bill.
Oh, okay. I'm sorry. Hit your button again. Back on the bill.
Okay, thank you, Mr. President. I know that a lot of you are going to have some questions, but before we get to questions, because we've kind of dealt with amendments already, I'd like to just continue explaining what the bill does now that the amendments have been adopted. I've explained to you the 3-year tiered system that now the DAs would be able to utilize when assessing these cases. People who can prove that their conviction was non-unanimous will remain in prison as their cases move through the system. So there should be no concern if there's a determination that a person's conviction was non-unanimous, that they will then be remanded to the local jail. They will remain where they are. People who can prove that their conviction was non-unanimous will have to stick to a jury trial if they are granted another trial, so they won't be able to pick a judge. I know that was a concern by Senator Morris. He and I had talked about that. He talked about certain judges. In cases where people were charged with a crime but convicted of a lower charge, the DAs will have an opportunity to present evidence that the dissenting jurors voted to convict of the higher charge. In those cases, the petition will be dismissed and the conviction will stand. As you all may know, we've done a lot of law changes recently as it relates to post-conviction relief and the Attorney General's ability to intervene in these cases. So any concern about rogue DAs, rogue prosecutors, the AG has more power than the AG has ever had to be able to intervene in these cases post-conviction. I mentioned that victims of sexual crimes will have the opportunity to opt out of retestifying. And also, it's common practice for DAs to try old cases in Louisiana. This is important because I know it's a concern of many of you all on DAs trying old cases. This is what Senator Morris just brought up. We don't have a statute of limitations for a reason. If trying old cases was a true barrier to justice, then we'd probably have a statute of limitations, but we don't have a statute of limitations. DAs try old cases all the time. And I'd like your attention, y'all. I know there's a lot of conversations going on. I'd like that if anybody can't listen to what I'm presenting right now, then you can maybe please take your conversations out, and I would ask for the president's support in that.
Okay, members, if we could have some order, please. Members.
Evidence could be lost or deteriorated. This is a concern not just for the prosecutors, but for who else? It's a concern for the defense too. So if the DA can't prove the case because they don't have evidence, it's hard for the defense to prove its case. If you're reading in old testimony, the defense can't cross-examine that testimony. So that means that that benefits the state, not the defendant. That's something that we have to keep in mind. SB 218 ensures that verdicts are constitutional, that victims can trust outcomes, and that the justice system operates with legitimacy and fairness. Okay, there's been talk around the panel. That's what Senator McMath just offered up. Got a lot of concerns with that. And while I do greatly appreciate his support, I want to thank Senator Royce for his work. We did a lot of work out of session to try to come up with some solutions to this. The concerns that we have is that that will invite more costs and more litigation. We already have a court system that's designed to deal with post-conviction. So why would we create a whole new tribunal with no accountability, no due process, and with absolute finality? That is a dangerous proposition. I want to go back to the holdings of what got us here today. Senator Jenkins talked about the Supreme Court. I want to read to you all the holding from the U.S. Supreme Court and the state Supreme Court. This is after the Ramos case, where non-unanimous juries were decided to be unconstitutional, but the decision was not made to make them retroactive. Which, by the way, the Ramos case could have said that we could not do this retroactively, but they didn't. So here in Edwards, the case on retroactivity in 2021, this is what the Supreme Court said. I hope you're listening. The Ramos rule does not apply retroactively on federal collateral review, but states remain free if they choose to retroactively apply the jury unanimity rule as a matter of state law in the state post-conviction proceedings. I think that was the Supreme Court's way of asking us to handle this. This was the Supreme Court's way of saying, look, this is not good. It's not constitutional. We're not going to make it retroactive, but states, please go right ahead and deal with it. They could have said, you can't make it retroactive, but they didn't. I believe this language makes it clear that they were asking us to do it. Would the Louisiana Supreme Court say, while we recognize the vitality and importance of the Sixth Amendment right at stake, we decline to act as a super legislature by issuing a broader retroactivity approach. We expressly note, this is the part, we expressly note that the legislature may determine that a subset of individuals are eligible for post-conviction relief. This is, again, the court's way of just screaming to us that the legislature has to solve it. Now, Oregon was lucky because their Supreme Court basically said it's going to be retroactive and you got to go fix it. And that's what they've been doing. Oregon was the only other state outside of Louisiana who had this stain on their justice system. And they are correcting it as we speak. And this is what this was the holding in the decision, Watkins v. Ackley. This is what the Oregon Supreme Court said, and then I'll go to questions. In Watkins v. Ackley, the Oregon Supreme Court held that convictions based upon non-unanimous jury verdicts are fundamentally unfair and violate the principles of justice, even if those convictions were finalized before the Ramos decision. The court stated that such convictions violate our sense of what is fundamentally fair in a criminal proceeding, thereby granting individuals the right to seek post-conviction relief. So we all agree that non-unanimous juries are unconstitutional. The question is, how are we going to deal with the hundreds of cases, the hundreds of individuals who were convicted by non-unanimous juries? And with that, Mr. President, happy to answer any questions.
Question, Senator Seabaugh for a question on the bill.
Senator Duplessis, thank you. I really appreciate your work on this bill. I think you know I don't really agree with you on it, but I do want to address some things. In the old days, when we allowed non-unanimous juries, when it was 10 not guilty and 2 guilty, what happened?
When it was 10 not guilty and 2 guilty,
Yeah,
you have not guilty.
you have a not guilty verdict. So my question is, would you allow an amendment to your bill, if your bill were to pass, that we would allow DAs to go back in those cases that were 10 not guilty and 2 guilty? Would you reopen and allow the DAs to recharge and retry those cases, since they were acquitted by the same non-unanimous standard?
I think that that's not an accurate comparison.
I think it is.
But I do appreciate you pointing out that DAs have the ability to try old cases.
But they don't now.
Well, no, I'm saying if we did this, you're saying if we took that amendment, you're saying that they would have the ability to try old cases.
Well, the law now, because they've tried, the law now is that they can't. After this.
No. I'm saying that if they had the ability, we're talking about from an evidentiary perspective,
and
that they could go back and try old
cases. It would be their choice, but
it's like it would be under my bill.
But you have to acknowledge the practical impossibility of retrying a case 10, 15, 20 years later. Evidence is destroyed, witnesses have died, witnesses have moved.
I want to be clear, I'm not dismissive of that, and I don't minimize that. And I don't expect that every one of these cases will be retried, but the problem is the DAs haven't even told us how many cases that they have. So we don't know for sure. You could have cases, let me go down, let me show you some numbers that I have, and you can contest these if you have some better numbers. But I know you represent a few different parishes, but I know you have Caddo, I think you have, what else you got? You got Caddo, do you have Red River?
Yes.
Okay, you got Caddo, you got Red River. All right, so Caddo looks like per year, the number of cases per ADA would be about 2.5 cases. And there was information provided. Now I've spoken to the DA from Caddo, and I've spoken to several DAs throughout this state, and I don't believe that they're hostile to this bill, right?
Now, look, I believe the DA of Caddo is.
Now, or where you, DeSoto? You got DeSoto too?
Yep.
And Red River. Okay, so we're talking about maybe 1 case per ADA per year. So I'm just saying, I don't think it's not that many cases.
1 murderer, 1 rapist, 1. These people got convicted, but
they didn't have a constitutional trial.
They did at the time. Are you aware of the difference between hung juries in state court versus federal court, where unanimous juries were always required?
The fact of the matter is that the courts have determined that these convictions they are unconstitutional. And if we were prohibited from going back, the courts would have prohibited us from going back.
But here's the problem. When the jury gets an instruction from the judge that says, when you get to 10 or 11, stop. They stop. They might have been able to get to 12, but hold on, but you don't know that. In federal court, where unanimous juries are required, they don't have more mistrials than we do in state court.
The problem is that you just said it. I don't know. We don't know. You don't. The standard is not they probably did it. The standard is beyond a reasonable doubt. And when you have 2 on that jury that we cannot say definitively what they would have done. Maybe they would have voted for the same thing. Maybe they would have voted for a higher charge. But the fact of the matter is that we don't know. And that undermines the standard of beyond a reasonable doubt.
The practical effect of this bill would be everybody that has one of these convictions would be moved to their parish court and have to be housed at local expense while they awaited a trial.
I literally just said that in my opening, that would not happen. The Ramos case, that will not happen. There's so much misinformation. We got to set the record straight. That will not happen. Ramos, the case that went up to U.S. Supreme Court, sat in Angola prison while his case was being processed. There is not a single defendant that will be moved to the local jail if it is deemed that they have a non-unanimous jury conviction. Ramos, who went through the process, stayed in Angola prison the entire time while his case went up for a retrial.
Well, the practical effect of trying all of these cases this many years later is almost impossible. Well, the defendants that are on your side have filed briefs in court claiming everywhere from 700 to 1,600 in Louisiana.
Well, what I'm saying is that
that's a lot.
It could be, but that would be up to the district attorney to decide. But every day in this body, and I believe you have legislation right now where we are constantly loading the courts up with more work. It's not an issue of whether or not they can do it. We can give them more resources. How about we give them more DAs, give them more dollars? This is an issue of justice, not efficiency. This is about what's right, not about what's easy or convenient. That's how we got to this place.
Well, the problem I have with it is you want it to go one way and not both ways. If you would allow the DAs to retry, to recharge those 10-2 acquittals,
I mean,
you might have some credibility on the issue. You're going one way, and you and I aren't going to agree.
Thank you.
Senator Jenkins for a question on the bill.
All right, Senator, we're talking about people who were convicted as a result of non-unanimous juries, right?
Yes.
We're talking about convictions.
Yes.
We're not talking about going back and picking up people just because they had a jury.
Yeah, I mean,
just because they had a jury trial.
that was a bit much.
All right.
That was a bit
And the
much.
passage of your bill is not going to lead to any kind of automatic release of anyone that's presently incarcerated as a result of
Absolutely
this.
not.
And so the Supreme Court has said that these jury verdicts need to be unanimous, correct?
Mm-hmm.
Louisiana voters have also said that we need to do away with non-unanimous jury verdicts. So the people of this state have spoken on this issue also.
They have.
Okay. The problem before us is that I want to say maybe those persons who were already convicted by non-unanimous juries before 2018 just does not have a recourse. That's what we're trying to address at this stage.
That's what we're trying to address.
And you would agree with me? I mean, if someone has been convicted by a non-unanimous jury, be it after or before 2018, if that is wrong, that's wrong no matter when it happened.
Right.
What your bill is actually trying to do, if we could just get to the point of it, is provide some kind of methodology by which our judicial system could take a look at these cases. That's not to say that every case that they look at, there's going to be some reason to let the person go. We're trying to set up some methodology that will allow that process to happen, given the fact that the Supreme Court has said something about it, given the fact that the voters of this state have said something about it. You're trying to get this legislative body to act upon it in a methodical way. That's really what we're trying to do with the bill, right?
That's what we're trying to do.
All right. And I think what you're doing makes sense. And hopefully this body will take a close look at it, see what the will of the people are, see what the will of the highest court has said. And if it's just a matter of people saying they are too busy, I mean, that's just not in the interest of justice at all.
No.
Would you agree?
No, I would agree.
Thank you, Senator. Thank you, Mr. President.
Thank you.
Senator Jackson Andrews for a question on the bill.
Senator Duplessis, I've heard a lot of questions today, and I heard a lot of questions. My last question, I think, that I heard was from Senator Seaball about innocent people, people that were ruled innocent being retried. And there have been a lot of overturning of wrongful convictions in the state of Louisiana, right?
One of the highest in the country. We're probably one or two, yeah.
Yeah. And so being one of the highest in the country, we have to recognize on this floor today and in every court that Louisiana courts have gotten it wrong sometimes.
Yes.
And that there may or may not be, most likely may, with being the highest in the country, some persons, based on DNA testing, based on how cases were handled, that are sitting in jail for 20 to 30 plus years innocent.
That's correct.
I've often thought, and I'm sure you have too, how it would feel to be an innocent person sitting in a jail. And have you ever thought about how it feels to be a father with a child that you're seeing growing up by pictures, even though you were innocent?
I wouldn't know what that feels like. I couldn't imagine.
Yeah, and me neither. And that's why I'm a bit confused how we bring the conversation of innocent people into a conversation of those who've been wrongfully convicted when we have the highest rate of wrongful convictions of any state.
Right.
And so as I understand your bill, it only seeks to give those an opportunity who were convicted by non-unanimous juries a chance to go back when there is new evidence.
No, there doesn't necessarily have to be new evidence, but the standard would be whether or not they were convicted by a non-unanimous jury, and they would then be offered, the district attorney would then have the opportunity to decide to retry them based on the evidence that they
Right.
have, or to plead them out.
And I guess I stated
Yeah.
it wrong. It gives the district attorney an opportunity to review our evidence.
Correct.
And so at no point are we alleviating the district attorney's role in these cases.
Oh, absolutely not.
And if the district attorney believes that the evidence at the time was strong and warranted conviction, he or she would have the opportunity to retry the case and put on all evidence.
Yep. Yeah, DAs retry old cases all the time. All the time.
By a number of procedures.
Yeah, of course. And not only do they retry old cases all the time, most of these cases that ended up with convictions were offered plea deals on the front end, right? So if we're talking about cases where people are now serving out long prison sentences, had they accepted a plea deal on the front end, they probably would be home already. So that is, again, this is not a perfect solution, but I do think given the injustice of being convicted by a non-unanimous jury whenever it was, the only way that we can truly reconcile, the only way that we can say that there's any integrity in our justice system is to either give these people a new trial or to offer them a plea deal. Because when we go down this road of saying, well, oh, that was the law at the time, well, there were a lot of bad laws at the time that we had to change. So this has been recognized by the courts as being unconstitutional. So there are people in prison right now that are serving sentences from unconstitutional convictions, and that's what we're trying to address.
And in this body, we look at a lot of constitutional provisions and we uphold them. We tout them as being a sacred right, the right to bear arms, right? We consider it sacred in this Senate and in the House. The right to life. I'm a major advocate of the right to life from the womb to the tomb, and we've said that that is sacred, right?
Yeah.
But a right for a free man, an innocent man, to be free is also a right that the United States Constitution recognizes.
Yes.
And so when there has been a ruling of the United States Supreme Court, right, that non-unanimous juries are unconstitutional,
Right.
why do you think it's important now to make sure those persons' rights upheld, their constitutionally protected right?
Yeah, look, it remains a stain on our justice system. And while the people, we as a body, and the voters of this state overwhelmingly said that we had to change this, that wasn't, we didn't finish the work. We didn't finish it because we had these convictions that are still outstanding that they didn't get justice. And while we might say, well, you know, they probably did it, you know, they got 10 people to say yes, that approach to justice is what got us here. That's why we're here today, dealing with this in 2025 when we shouldn't be. But that putting efficiency and convenience before justice we will never have a just state. We will always be plagued by this. And it's going to lead to it's going to continue to breed distrust in our system and more inefficiency. That's why we have to correct this.
And I believe, and I'm sure you do too, right, that it is the general consensus of humanity that we can help an innocent man, a woman walk out of a facility they've been wrongly convicted to serve life in, 30 or 40 years in, then we should do that, right?
Absolutely.
Thank you.
Thank you.
Senator Boudreau for the floor on the bill. Anyways, Senator Duplessis to close.
Members, I'm gonna ask that you just try to tune in, because I really don't know how many more times I'm going to speak on this. You know, nothing's promised in this world, and I'm grateful for the opportunity to serve in this body. So I just want to give you some closing thoughts on this. I want to take a moment to thank you all as my colleagues. I have talked to most, if not all of you about this. This is not something that I take a lot of joy in, I'll be honest with you, but this is also something that I feel called to do, as difficult as it is. I don't think that this is easy. I want to thank the Promise of Justice Institute for the work that they do. I believe it's truly God's work that they do. I want to thank the numerous district attorneys across this state that I've had the opportunity to talk with and have constructive conversations with and dialogue with. District Attorney Paul Connick, District Attorney James Stewart, District Attorney Tony Clayton, who I had some really good conversations with, LDAA President Christine Russell. I want to thank the Pelican Institute for their firm and unwavering support. I want to thank Congressman Clay Higgins for his firm and unwavering support. I don't know if you all saw the letter, but I'd like to read it. It was sent to the body, addressed to Senate President Henry, and it reads, I strongly support Louisiana Senate Bill 218, introduced by Senator Royce Duplessis, and urge its immediate passage this legislative session. Every elected representative has an obligation to ensure faithful service to our citizenry by preserving due process, including the right to a fair trial, as a core principle of our constitutional system. SB 218 advances that mission and offers an opportunity to extend relief to those who may have been wrongfully convicted under the former non-unanimous jury system in Louisiana, which has been struck down by the U.S. Supreme Court. SB 218 would update the Louisiana State Code to permit those convicted under state law without a unanimous verdict to pursue post-conviction relief through the strict processes already codified in state law. Consistent with the Supreme Court's ruling on the former non-unanimous process, Senator Duplessis's important legislation would bridge the gap between the rights afforded under the current and former systems to ensure justice under the law. I dutifully urge the swift passage of Senate Bill 218 and fully support this legislative writ. which codifies an avenue of relief for those lost in the gap between Louisiana's old and new judicial processes in accordance with the Sixth Amendment of the U.S. Constitution. Respectfully, Clay Higgins, Member of Congress. You could not have told me in my 42 years on this earth that I would have a letter from Congressman Clay Higgins supporting a bill that I brought. I'm not sharing that for laughs. I'm sharing that to show you the gravity of this moment. This is serious. And I know we got tort reform bills and all that other stuff that we got to debate that people are working hard on and we're tired, but this is serious. I talked to Tony Clayton a few nights ago, and I thought he was immediately going to shut me down. And he said, Royce, you're doing the right thing. Now, you find me somebody that's more tough on crime than Tony Clayton. You won't. I said, I need you to give me some advice because I don't know how to do this, and I don't think I can get it done. He said, you need to look up, you need to go use your AI skills and look up what Ronald Reagan would say about SB 218. I said, why would I do that? He said, you just need to do it. So I said, I looked it up. And this is what it said. It said, our Constitution was written not to guarantee government power. It was written to protect the rights of the individual. If a man or a woman was convicted by a jury that did not speak with one voice, if the very foundation of our justice system, the unanimous jury, was denied them, then we must ask, was that truly justice? We can't call ourselves the shining city on the hill if we know that there are people in our prisons who might not be there had their verdict come from a fair and constitutional process. SB 218 isn't about being tough or soft on crime. It's about being firm on justice. And justice, true justice, should never be partisan, and it should never be retrospective only for those lucky enough to be in the right courtroom at the right time. Members, justice has no expiration date. And if we choose to vote down this bill, that's what we're saying. We're saying that justice has an expiration date. We're saying tough luck. We're saying that we do not want to restore the faith in our justice system. We have an opportunity right now, Louisiana, to remove this stain, because right now we are the only ones who are wearing it. A poll was done recently, and I know we like to use polls selectively, but 65% of the people of this state support this. And each one of you know in your heart that if this went to a vote of the people tomorrow, that it would pass overwhelmingly. Has support from the state Republican Party, has support from the Pelican Institute, has support from Congressman Clay Higgins, Freedom Caucus. What more do we need? A couple of DAs, I get it. I'm not minimizing the concerns of the justice system. But I don't think we were sent here to do the easy stuff. We were sent here to do the hard stuff. And I know that this vote is hard for many of you, but in many ways it's simple. Do we affirm the past, or do we break free from the past? Because we're standing here today in 2025 because of the past. So we can pass the buck, look the other way, and let our children and grandchildren have to deal with this, or we can fix it right now. It's a simple choice. It's a simple choice. What's our legacy going to be? Because this vote, this is our legacy. And I'm asking you, as members of this body, to not let efficiency or convenience get in the way of courage or what's right. We're here because of convenience and efficiency, and this is what we have to deal with. Let's end it. Let's fix it. And with that, members, I humbly ask for your consideration. I move for final passage. Thank you.
Senator Duplessis must finally pass Senate Bill 218. When the machines are open, all those in favor vote yes, opposed vote no. Madam Secretary, open machines. Vote your machine, members, vote your machines. Vote your machines. Madam Secretary, close machine 9. Does the author give notice? Yes, he does. The final vote is 9 yeas and 26 nays, and the bill fails to pass. Next bill.